Hello, welcome to the 225 Literary and Jury Charge. We're going to start off with some legal terms and a paragraph, and I am going to read this at 200. Okay, so we're going to start out with a word list. Ready? Voluntarily, verbatim, jurit, clause, interrogatories, docket, contempt, transcript, disclose, deposition, format, concealment, affidavit, official, executed voluntarily. And here's your paragraph. Ready? A voluntarily written statement executed under oath before an official of the court is called an affidavit. A jurit clause appears at the end of an affidavit. Interrogatories are questions answered under oath outside of the courtroom. The court reporter prepares a verbatim transcript of most proceedings. The disclosure of facts known about a case is prepared in question and answer format in a deposition. A party is guilty of concealment when the facts known about the case are withheld. This action can lead to a contempt of court charge. The trial date for a case is entered on the court docket. All right. Moving right into my next selection. This is going to be literary. The subject is licenses. Okay. And let me give you a word list. We've got occupation, pilots, plumber, penalty, electricians, barbers, practitioners, drugstores, accountants, lawyers, license, occupation, public. And here is your paragraph. Ready? The formal permission granted by the school, state, or federal government to engage in a stated occupation or to carry on certain business activities is called a license. The two main purposes for requiring licenses are to collect taxes and to protect the public. Licenses are required for many professions, such as doctors, lawyers, and accountants. Licenses are required in many businesses, for example, liquor stores, insurance companies, and drugstores. Skilled practitioners, such as barbers, electricians, pilots, and plumbers, need licenses to conduct their affairs. The penalty for operating without a license or valid permit varies from state to state. Many states, in addition to changing a license fee for skilled practitioners, have developed proficiency or proficiently licensing examinations. These examinations require the applicant to meet certain standards of expertise in their selected field before a license will be granted. Okay. I have some expert opinion. I'm going to give you a word list. I'm going to read this at 200. We've got electronic, destructive, explosive, flashpoint, ammunition, caliber, flammable, detonate, tracer, Oklahoma, sophisticated, instantaneous, Tulsa, mechanism, diameter, missile, incendiary, chase, destructive, nitroglycerin, dynamite, hardening, combustion, chemical, rocket, grenade, projectile, bomb, electronic. And here is your article. Ready? I'm going to read this I'm going to start off at 180 and then I'll move my way into 200, okay? Here we go. Ready? The problem is to determine if the special circumstance referred to by Mr. Chase is true. Was murder perpetrated by an electronically constructed device, bomb, or explosive unit? We must determine and prove that the murder was committed by means of a destructive device, a bomb, or an explosive mechanism. For purposes of a definition, a destructive device includes any of the following weapons: any type of projectile containing explosive or incendiary material or any other chemical substances which are commonly known as incendiary ammunition, except tracer ammunition manufactured for the use in shotguns. Any bomb, grenade, explosive missile or missile device, or any device used for launching. any type of weapon of a caliber greater than a 50 caliber, which fires standard ammunition other than a shotgun, any rocket, rocket-propelled projectile, or other device of a diameter greater than 80% of an inch of any rocket, rocket-propelled projectile, or other device which contains explosives or incendiary materials or any other chemical substances, any breakable container which contains a flammable liquid with a quick flash point of 160 degrees of capable of being ignited. For the purposes of clarification, I will define a bomb. A bomb is any device that carries with it an explosive charge designated to detonate under special conditions. These conditions include point of impact, a timing mechanism, or merely setting in a position at a given point with variable effects. An explosive means any substance or a combination of substances with the primary purpose or goal of detonation or rapid combustion. An explosive is capable of a relatively instantaneous or rapid release of gas and heat, and the primary purpose of which, when combined with others, is to form a combustible substance. The term explosive includes nitroglycerin, dynamite, black powder, gunpowder, and smokeless powder, as well as other more elaborate and sophisticated chemical combustions. Was it a destructive device, a bomb, an explosive? We will need to evaluate all of the evidence that was gathered at the scene of the crime at 18403 West Harding Boulevard, Tulsa, Oklahoma. We must determine if a device was planted, hidden, or concealed. We must determine if the device was in the structure, in the adjacent building, in the parking lot. Another alternative that we are looking at is the possibility of the device being mailed to this address. Someone knew of these facts, which were a potential threat to human lives. Okay. Moving right into our next segment. I've got some final argument for you. Here we go. Ready? Thank you, Your Honor. It seems like every time I get up to argue, the heat goes up in this room. It is a sign of something. What I would like to do today, considering the nature of the temperature in here, is begin with a defense which was mentioned to you, and that was the heat of passion. It seems appropriate to start with that. Hopefully, it will cool down a little bit in here. The court is going to instruct you to reduce an intentional felonious homicide from the offense of murder to manslaughter upon the ground of sudden quarrel or heat of passion. The provocation must be of such character and degree as naturally would excite and arouse such passion. Therefore, it is clear they define the term heat of passion for you as follows: such passion as naturally would be aroused in the mind of an ordinarily reasonable person of average disposition in the same or similar circumstances as those in question, and such as would cause him to act rashly without reflection and deliberation, and from passion rather than judgment. What that instruction means is that the defendant cannot set up his own standard in the case, Ryan Burton's standard. If he is a quick-tempered person and there is some form of provocation that leads him to believe that self-defense is necessary, it is not his standard that we judge it by. We judge it by an ordinarily reasonable person would do in the same situation. The court will tell you that if there was a provocation of such a nature not calculated to naturally arouse passion, if an unlawful killing of a human being follows such provocation and has all of the elements of murder, then the mere fact of slight or remote provocation will not reduce the offense to manslaughter. What was argued to you by Ryan Burton sees the weapon and suddenly he feels threatened by it. And this is provocation on the part of Fred Adams. And because of Ryan Burton's reaction to this, there is a sudden quarrel. A heat of passion takes over. He cannot premeditate and deliberate. He can't be guilty of murder. Therefore, Sean Zachary cannot be guilty of murder as an aider and abetter under those theories. It is our contention that obviously there was no heat of passion. There may have been an element of fear in the mind of Ryan Burton, but that is covered in the next instruction. Okay, and that was read at 200. I should have let you know before I started that. All right. I've got an excerpt from Don't Sweat the Small Stuff. Here we go. And I'm going to read this at 200. Ready? Often we allow ourselves to get all worked up about things that upon closer examination aren't really that big of a deal. We focus on little problems and concerns and blow them way out of proportion. A stranger, for example, might cut in front of us in traffic. Rather than let it go and go on with our day, we convince ourselves that we are justified in our anger. We play out an imaginary confrontation in our mind. Many of us might even tell someone else about the incident later on rather than simply let it go. Why not instead simply allow the driver to have his accident somewhere else? Try to have compassion for the person and remember how painful it is to be in such an enormous hurry. This way we can maintain our own sense of well-being and avoid taking other people's problems personally. There are many similar small stuff examples that occur every day in our lives. Whether we had to wait in line, listen to unfair criticism, or do the lion's share of the work, it pays enormous dividends if we learn not to worry about little things. So many people spend so much of their life energy sweating the small stuff that they completely lose touch with the magic and beauty of life. When you commit to working toward this goal, you will find that you will have far more energy to be kinder and gentler. All right. I've got expert testimony from a handwriting expert. I'm going to give you a word list before we start. Okay, how are we doing on time? All right, so we've got Sheila Webster, retrace, horizontal, straight, hump, upstroke, proportion, downstroke, yellow, similarity, retrace, fingerprint, handwriting, overlapping, narrow. And I write fingerprint as initial F, final P. All right, so I will read this at 200. Ready? My first comparison is with the signature Sheila Webster on the fingerprint card. The photograph has the signature Webster from the fingerprint card with the unidentified writing on the yellow document agreement. Notice the word whereas. The comparison is between the capital W's. The pickup stroke in both capital W's is low. That is, it hits the peak of the stroke. It is approximately 2/3 the height of the letter in the known handwriting and the questioned handwriting. The downstroke to the baseline is fairly straight with a retrace or somewhat overlapping. The stroke goes to the top of the letter in both known writing and questioned writing. The center of the capital letter W is open on the upstroke, and the downstroke in both the known writing and the questioned stroke is a retrace up in the known writing approximately the same height as the pickup stroke, and in the questioned writing only about halfway to the letter. The characteristics in the form of the letter W, in my opinion, show a distinct similarity in the known writing and the questioned writing. The next, the top signature in the word Madison from the fingerprint card, is compared with the word from the yellow paper, the agreement. The comparison is made on the smaller D. The body of the D has a long overhanging stroke. The body of the letter D is very narrow and long, both in the known writing and the questioned writing. The final stroke of the body of the word or of the D rises to a point, leaving an opening in the body of the D. The staff of the D is straight and long. The staff of the D is approximately 4 to 5 times the length of the body in proportion in the known writing and the questioned writing. In this same photograph, the small letter S in Madison shows the characteristic of the initial stroke to the top of the letter W, a tip or hump on the top left-hand corner of the small letter O with the horizontal top to another sharp point in the upper right-hand corner of the small letter N. A similar characteristic is found in the questioned smaller letter N. There are variations of this, and that will be compared in the other exhibits. Right. Moving right into some land description. Here we go. Ready? I'm going to read this, I think, at 180. Okay, here we go. Beginning at the south end of Box Culvert in the northwest corner of the northeast 1/4, section 22, running thence southerly and southerwesterly through the northeast 1/4, northwest 1/4, and the northwest 1/4, southwest 1/4, section 22, thence westerly and southwesterly through the southeast 1/4 and northwesterly through the southwest 1/4 and northwest 1/4, section 21, thence northwesterly through the northeast 1/4, northwest 1/4, section 20, and the south 1/2 of the southwest 1/4, section 17, terminating at a point 21 feet north and 17 feet west of the northwest corner of southwest 1/4, southwest 1/4, said section 17. Okay, I'm going to read that one more time now at 200, okay? And I know it's probably a little bit more difficult just because it doesn't make a whole lot of sense. You know, it's land description. So just write what you hear, okay? So here is, I'm going to read this at 225. I'm sorry, 200. Ready? Beginning at the south end of box culvert in the northwest corner of the northeast 1/4, section 22, running thence southerly and southwesterly through the northeast 1/4, northwest 1/4, and the northwest 1/4, southwest 1/4, section 22, thence westerly and southwesterly through the southeast 1/4, and northwesterly through the southwest 1/4, and northwest 1/4, section 21, thence northwesterly through the northeast 1/4, northwest 1/4, section 20, and the south 1/2 of the north or southwest 1/4, section 17, terminating at a point 21 feet north and 70 feet west of the northwest corner of the southwest 1/4, southwest 1/4, said section 17. All right. Now, moving right into some jury charge. This is on assault and battery, and the brief for that is SAUB. All right. I'm going to read this. I'll read this at 200. Here we go. Ready? Actually, you know, I'll read this at 225. It's not too terribly challenging. So I'll read this at 225, give you guys a little push. Okay? Here we go. Where an unlawful trespass is being committed upon the property of another, the owner may lawfully use the amount of force which is necessary under these circumstances for the protection of his property, either real or personal. However, he will be guilty of assault if he uses excessive force or any force after the necessity therefore is past to justify a resort to force in defense of property. The danger should be as to induce one exercising reasonable and proper judgment to interfere to prevent the consummation of the injury, throwing a stone which is capable of inflicting grievous bodily harm at a person, even though such person is a trespasser, constitutes an assault if the purpose was to commit grievous bodily harm. Ordinarily, one who is in possession of premises lawfully and who has requested or ordered another to leave, whom he had a right to so request, may lawfully use as much force as is necessary to remove such other after allowing him a reasonable time to depart, and the trespasser may not resist if only reasonable force and agencies are used or employed in making such ejection. This right applies to any property lawfully in possession. However, anyone ejecting a trespasser will be guilty of assault if he uses more force than is necessary, as when he is or uses a dangerous or deadly weapon, unless the trespass is made with hostile intent and actual force. The general rule is that the owner may use only such force as is necessary to eject the passenger or the trespasser. A man may not use a deadly weapon to resist a mere trespass, but he may resist the trespass with sufficient force. If while so resisting he has reasonable ground for believing that he himself is in personal danger, then he may use a weapon to defend himself and his property. It is clear that a man has no right to commit an assault with intent to do great bodily harm to another for a wrong that he does not have reasonable ground to believe to be dangerous to himself. If a person honestly believes or has reason to believe that he is in great peril and that great bodily harm is about to be inflicted upon him, He has a right to act under such well-grounded apprehension and may use a weapon even though the danger does not in fact exist. However, in the absence of a felonious invasion of one's property, that is, in the absence of an invasion with intent to commit the crime of felony thereon, one does not have the right to inflict serious bodily injury in the defense of property interest alone. The defendant in this case, after requesting the plaintiff to leave the premises, had the right to use reasonable force to eject him, but no more force than was reasonably necessary. If in protecting his land from trespass only he intentionally inflicted grievous bodily harm upon the plaintiff and was not himself in reasonable fear or danger or bodily harm to himself, then he committed a wrongful assault upon the plaintiff. All right, so we are going to conclude our 225 literary and jury charge. Thank you.